Get ready for the dictation in 3, 2, 1, start. Before us, Mr. Deepak Kapoor, learned counsel appearing on behalf of the appellant, impugns the aforesaid order by arguing that ITAT has committed a grave error, having failed to take into consideration that transactions related to shares of aforenoted three listed companies were carried through its registered share broker, Messrs. Elite Wealth Advisory Limited, on Bombay Stock Exchange, which is a recognized stock exchange. He argues that there was no possibility of any nexus between buying and selling brokers since the appellate carried out transaction through a registered broker. Learned counsel further argues that the SSC has discharged the onus and substantiated STCL arising out of sale transactions of the aforenoted three companies by sufficient documentary evidence produced before the AOCIT and the ITAT. None of the documents produced were rebutted or contradicted by the authorities. The appellant had discharged the onus and substantiated STCL, and in these circumstances the additions are not sustainable. Once the ITAT held that Section 68 is not applicable since it was a case of cash debit and not cash credit. The burden of proof was on the revenue to sustain the addition by leading cogent evidence. The Income Tax Department failed to gather and produce any credible material in support of treatment of STCL and bogus, and therefore the order of ITAT upholding the additions is unsustainable. We have given due deliberation to the contentions of the appellant. However, we find that no substantial question of law arises for our consideration to entertain the present appeal. The SSC in the income tax return set of STCL of rupees 1,22,76,352 relating to sale of shares of three companies. This was disallowed by the AO, holding the same as part of accommodation entry business of providing bonus long-term, short-term capital loss. The AO relied upon the report of the Deputy Director of Income Tax Investigation Unit 2-3 Kolkata, wherein the general practice followed by the companies, brokers and operators for providing LTCG/STCL to beneficiaries has been explained. The involvement of the SSC in the entire chain of generating bogus entries of long-term capital gain/loss were taken into consideration. The AO concluded that the SSC was not a regular investor in shares and had invested only in high-risk stocks which during investigation were found to be obscure companies with no business activity or asset and were identified as penny stocks. The AO concluded that the SSC had entered into a sham transaction with full knowledge so as to convert unaccounted money into accounted money in the guise of capital loss. Further, the evidence in the nature of testimonies of person in charge with the management and control of the aforenoted penny stock companies were also taken into account. This evidence forms the basis for the assessing officer to conclude that the STCL claimed by the SSC was not genuine or market driven but was a pre-arranged transaction noted in the accounts of the SSC in lieu of unaccounted cash. Although the AO and CIT treated the capital loss as an unexplained entry under Section 68 of the Act, the ITAT held that said provision is not attracted. However, ITAT still sustained the additions, observing that STCL should be disallowed as the same has resulted from bogus transactions. This finding of fact is based taking into consideration the entire evidence on record and also the views expressed by this court in the case of Suman Poddar versus Income Tax Officer ITA number 841 2019. The relevant portion of the impugned order is extracted herein below. The first issue which has been raised by the SSC that it has not been confronted with the statements of various parties relied upon by the assessing officer. Stop. Thank you.